Good afternoon. This afternoon, we have the Committees on Public Safety and Military Affairs and Waterland, Culture and Arts on a joint agenda. First up, we want to announce that the meeting is being streamed live on YouTube. In the unlikely event that we have to end this hearing due to technical difficulties, the committee will reconvene to discuss any outstanding business at 3 p.m. February 5th, 2026 in conference room 016, and a public notice will be posted on the legislator's website. Each testifier will be given 2 minutes to testify. If you have already submitted your testimony, please limit your time to highlighting important facts or standing on your written testimony, which would be greatly appreciated. First up, Senate Bill 2723 relating to the State Sheriff's Day. This bill establishes April 27th as State Sheriff's Day to commemorate the establishment of the Office of the Marshal of the Kingdom of Hawaii. And, first up, we have.
Are you the king of Hawaii?
Not yet, but I'll let you know if that works out. And Sergeant Malani, please.
Yeah, you just got appointed.
So good afternoon, Chair, Vice Chair, members of the Joint Committee. My name is Mike Lambert. I'm the Director of Department of Law Enforcement, and I'm very grateful for this bill to be introduced. When the Department of Law Enforcement was consolidated, some of my sheriffs felt as if it diminished their role or relevance. So this would really elevate the fact that the deputy sheriffs have a longstanding history. I've asked Sergeant Malani to give a very brief history. He's the longest serving sheriff. He's been serving since 1981. So to put that into context, I was crawling when he first began to serve our great state. So I cut into your time, but you got 90 seconds.
Yes, sir. Mahalo. Esteemed committee, mahalo for this time. I know my time is limited. The sheriffs express a deep pride in where we come from because the sheriffs here in Hawaii were created under the Kingdom of Hawaii by Kawikioli, Kamehameha III. And we were actually designated the sheriffs under the Marshal of the Hawaiian Kingdom, which was Henry C. at the time. And this came about in 1846, after the 3 grand divisions of government were created by Kawikioli, the legislative, judicial, and the executive branch. I give history to our new deputies, our new recruits, and I've been doing this since we began basically pushing for recognition. And this goes back to our beginning because the sheriffs are unique in Hawaii. We transcend from England, feudatory England. We go as far back as 992. And because of that proud history, we're incorporated with a worldwide group of sheriffs, 4,559 sheriff's departments, and we share a camaraderie with them. In 1940, Sheriff Duke Pauakamoku incorporated us. He had us included with the National Sheriff's Association with the United States on Duke Street in Alexandria. And okay, it's really fast.
If I could ask you to kind of summarize.
In any case, we have a proud history and want to thank you for this opportunity for recognition. And I do have some brochures and handouts for you folks to read.
Okay. And we'll give that to you folks. We realize there's a long agenda, but if you guys are interested, he will stand by to the end of it. And if you guys have any questions on the posters we have, he'll be available for you folks. Thank you.
Thank you very much.
Thank you, ma'am. Allah.
Okay, next we have HGEA. Okay, they submitted written comments. Is there anyone else who would like to testify on Senate Bill 2723? If not, let's move to Senate Bill 17 relating to wildfire mitigation. First testifiers, I believe, are Public Utilities Commission. Is representative present?
Chairs, Vice members of the committee, I'm Ira Howe, representing the commission today and the state honor.
Thank you. Next, we have Department of Land and Natural Resources, Michael Walker. Mr. Walker.
Aloha Chair, Vice Chair, members of the committees. Uh, I'm Michael Walker. I serve as the statewide fire protection forester for the Department of Land and Natural Resources, Division of Forestry and Wildlife. The department stands on this testimony as written, but I'd also like to add that we support the testimony of the State Fire Council and the Fire Marshal with the amendments that they proposed, and I'm available for any questions.
Thank you very much. Next, we have Department of Hawaiian Homelands, which is submitted. Okay, thank you. Next, we have Gary Lum, individual, who is on Zoom. Mr. Lum, please proceed.
Good afternoon, Chair, Vice Chair, members of the committees. My name's Gary Lum. I'm testifying on behalf of the State Fire Council, and we're standing on our written testimony that was submitted with suggested amendments.
Thank you very much. Mary Alice Evans, also commenting in person.
Aloha chairs, vice chairs, members of the committee. My name is Danielle Bass from the Office of Planning and Sustainable Development. We would like to stand on our testimony supporting the intent of the bill. We offer comments as to how the working group should be placed and in the structure of the working group. We do appreciate being a part of the working group and look forward to participating in that in a collaborative manner. However, due to the costs, we think that this does require some dedicated staff capacity, technical expertise, and reliable funding to be effective. And we suggest perhaps aligning the staffing and funding with an agency that already leads wildfire response, land management, and fire safety functions that will strengthen our statewide coordination and implementation. Thank you.
Next, Attorney General's Office, Allison Kato or Christopher Law.
Good afternoon, chairs, vice chairs, members of the committee. It's Allison Kato, Deputy Attorney General. We submitted written comments on a few points. First, the Constitution requires that groups such as this working group be established within a principal department. So we recommend placing this in DBED because that's where OPSD is, or if you feel another department is appropriate, that's fine too. Second, there's a technical correction in the reference to State Fire Marshal, which we've known in our written testimony. And third, we just wanted to note that some of this bill may be overlapping with the effects of Acts 302 and 303 that passed last year. We've included details in our written testimony. I'm available for any questions. Thank you.
Okay, thank you. Next, we have Elizabeth Benishek for Nature Conservancy. Michael Hayashida for Kamehameha Schools.
Good afternoon, Chair Fukunaga, Chair Lee, Vice Chair Inouye, and committee members. My name is Mike Hayashida. I'm representing Kamehameha Schools. Aloha. I've been in this position for about a year, and my position is Wildfire and Risk Manager for Kamehameha Schools. Prior to this, I worked in the Hawaii Fire Department for 32 years as a battalion chief. Was my last 12 years in the department. And currently, I'm a National Fire Protection Association certified wildfire mitigation specialist. We already submitted our written testimony. I'd just like to highlight a few points. We'd like to request that 2 other members be added to the working group. The first one being a cultural specialist. Hopefully that could be selected by the DLNR representative. The second being selected by the State Fire Marshal, and basically a representative of large landowners. And the reason being is if you look on page 1, the end of sentence 8 and 9, it stipulates large landowner. However, when you look in the bill, it doesn't stipulate large landowner as a member of the working. Those 2 things stick out in our mind. Other than that, I'll be here for any questions.
Thank you
Right,
very much.
Thank you.
Okay, next we have Hawai'i Electric. If anyone is present, they have submitted comments and support. Finally, Jordan Roth. Okay, if not, is there anyone else who would like to comment? If not, members, any questions?
OPSD.
OPSD, can we have you return to the table?
Thanks for being here. Does this conflict with the measure that we passed previously, Act 302 and 303, when we created the wildfire? Didn't we give it to you guys last year?
I am not aware of that. I'm
Okay, do
sorry.
you know anything about Act 302 and 303?
No.
As noted by the Attorney General. Come on up.
This is Senator Inouye's bill, so she may
Yes.
be a lot more intimately involved in
Miss
this.
Sariaji?
I actually don't. In our testimony, we've described, I guess, the similarities and with references to specific sections.
Oh, okay. So someone else probably in this introduction of this wasn't probably aware that there was already an established groove. But I think that measure went to Fire Marshal.
Yes,
Yes.
that's correct.
Okay. Do you see does this SB 17 directly conflicts with the measure we passed in 302 and 303? Because this is creating the, yeah.
This testimony was actually included by another deputy who is very familiar with Acts 302 and 303 from last year. But my understanding, I don't think it directly conflicts with it so much as there's overlapping results.
Okay.
So what's sought to be accomplished by this bill may already be happening with that bill, those
I
acts.
understand. Okay, thank you.
Okay.
Thanks so much.
Any
Thank
further
you.
questions? If not, we're gonna turn it over to Waterland.
All right, thanks very much. Moving on to the next measure, Senate Bill 2358 relating to search and rescue, which requires government entities to seek reimbursement for all or a portion of search or rescue expenses for persons who require rescue after leaving the hiking trail to enter an area closed to the public. Testifying first on 2358 is the Hawaii State Fire Council.
Good afternoon again, Gary Lum with the State Fire Council. We stand on our written comments that were submitted and available for questions.
Thank you. Also sign up to testify. Online, we have the SAR Alliance, Rosemary Johnson.
Okay, hello. Okay, it wasn't on. Hi, thank you very much for having me. And I am speaking on behalf of the Hawaii SAR Alliance, a collaborative effort that has been involved for the past 5 years, but bringing together multiple agencies, teams, and organizations to conduct search and rescue across the state of Hawaii. And I stand by our written testimony submitted and would like to just simply add that each year legislation related to search and rescue is introduced and experiences opposition as there's no foundational support to effectively implement the proposed bills. As it stands now, there are existing structural and administrative gaps within Hawaii's fragmented SAR system that spans over a dozen different agencies and jurisdictions that should be addressed prior to implementing reimbursement mechanisms. For SAR reimbursement policies to be effective and sustainable. So right now there is a proposed bill SB 2938 for a state SAR coordinator, and we would recommend that this type of legislation be held off until such a coordinator is put in place. I'm here for any additional questions.
Thank you. That's everyone who had signed up to testify. Is there anyone else wishing to testify on SB 2358? Seeing none, are there any questions? If not, I have just one real quick for the Fire Council. Mr. Lum, if you're still online.
Yes, sir.
Thanks. I think there's been a number of these bills over the years, but this one in particular, several of the testifying agencies had raised the same issue, which was if there's a penalty or fee or something that someone would have to pay if they're rescued, that it might deter them from calling for help when it's probably most helpful. Is there a path forward where other places have explored this and come up with a mechanism that doesn't have a deterrent effect?
From what I know from State Fire Council meetings, I believe the County of Kauai has implemented a similar measure. And from our discussions with the Kauai Fire Chief, he does not know of any situation where they have sent an invoice or bill to any of the persons they rescued.
Okay,
I have
thank you very much.
I guess based on, many years of instances where we've had trespassing into areas that were not really in which hiking or other kind of activity was not really allowed. The consistent, commitment has from the search and rescue entities has been that they didn't want to see us seek reimbursement. However, as the costs of government increase and we have shortages in law enforcement throughout the community, do you know of any other penalties that could be imposed that didn't necessarily include reimbursement? Say, for example, some sort of penalties that attach to either driver's license or other kinds of regulatory frameworks in which individuals who may be trespassing and for whom, search and rescue operations must be carried out could be penalized in a way that doesn't necessarily involve additional costs.
I'm sorry, was that a question for me at the State Fire Council?
Yes.
Oh, I'm sorry. Gee, I really couldn't say. I'm not a subject matter expert in law enforcement, but perhaps maybe the sheriff or Department of Law Enforcement could address that question.
Okay. Director Lambert, I mean, given that many of these instances involve, locations where hiking is not permitted anyway, and people who are trespassing are usually violating the law. So, it's sort of like fireworks in that if there's no penalty or there's no deterrent, people continue to break the law. So I think in other areas, you have identified some alternatives.
I mean, as regards to pathways, I mean, and again, I'm kind of coming off the cuff here without any ability to research. But yeah, if you were to, let's say, garnish their taxes or do other things for the cost of it, that may discourage. Of course, it gets problematic if they're out of state and how you would recoup that. But I'm sure that there's other avenues that could be used to deter instead of going down criminal proceedings.
Okay, thank you very much. Sorry, thank you.
Any further questions? Seeing none. All right, thank you very much. Let's move on to the next measure, SB 2475, relating to Red Hill, which appropriates funds for studies on remediation of substances released from the Red Hill bulk fuel storage facility, monitoring, testing, and other sorts of research. And requires DLNR to seek reimbursement from the Department of Defense, U.S. Department of Defense. Testifying first on SB 2475 is the Board of Water Supply. Oh, I'm sorry. Oh, yeah. Okay, sure. Good afternoon.
Aloha, good afternoon, chairs Fukunaga and Lee, and members. Ernie Lau, manager for the Board of Water Supply. We are in strong support of this measure that provides financial resources to the Red Hill VI to continue the efforts to do more investigations, collect data. Red Hill is not POW. We are now entering the phase of trying to figure out where past leaks went into the environment, into the Aina and the VI. And the challenge is going to be how to clean it up. But so mahalo for your support.
Thank you. Up next is the Department of Land and Natural Resources. Good afternoon.
Good afternoon, chairs, vice chairs, members of the committee. Kayala Richardson, DLNR. I'm the policy coordinator for the Red Hill Water Alliance Initiative, or VI. DLNR submitted written testimony and support. And I just wanted to highlight two important points. One being that defilling of Red Hill marked an important step in this progress. However, there's decades of research, remediation, and monitoring that are necessary to protect groundwater resources, restore INA, and rebuild public trust. And the second point is that this measure advances those VI initiatives in collaboration with various UH teams, teams from the School of Ocean and Earth Sciences, and the departments of Civil, Environmental, and Construction Engineering, Geography, the Natural Resources, and Environmental Management, including the UH Water Resources and Research Center, and also UH Community Colleges, Leeward and Honolulu. So I'm here today. There might be some subject matter experts that are part of these teams that are available for questions, but I can do my best to answer some of those questions today. Thank you.
Thank you. Testifying next is signed to testify on Zoom is Sierra Club of Hawaii.
Good afternoon, chairs, vice chair, members of the committee, Wayne Tanaka, Sierra Club of Hawaii. I will stand on a testimony in strong support of this measure. Thank you very much.
Thank you. That's everyone who had signed up to testify. Is there anyone else wishing to testify on SB 2475? Seeing, oh.
This bill, and I just want to add in just a few amendments just to clarify administrative purposes only, just to ensure that, DLNR cannot reassert control over CWARM decision-making to make them, completely independent, and to reconsider ex officio voting membership for BLNR and DOH, or to narrow its scope, to avoid reintroducing political pressure to commission votes. And finally, and lastly, just to make sure that this is solely used for Red Hill contamination response and protection of potable water. And so that is not repurposed for unrelated development or extractive uses without clear public notice, review, and consent. And again, yes, we need to have the Department of Defense pay for this remediation and cleanup and for the studies as well. Mahalo.
Thank you very much. Anyone else wishing to testify on this measure? Seeing none, are there any questions?
If Chair, DLNR, please. Thank you for spearheading this important responsibility that we've had with VI. However, with Red Hill, there was an interest, and I remember that Congresswoman Tokuda and some of the members of our congressional delegation, this was a hot item for them. And I remember, I think there was a potential appropriation. Did we receive any funding from the feds yet, or Congress?
That's a great question, Senator. To my understanding, there hasn't been any state appropriations. Most of the federal appropriations are to like Indo-PACOM or directly to the Navy to handle remediation, monitoring, and for public engagement.
But we haven't received any into the state.
The special fund for Red Hill remediation was established in 2025. So the special fund as it is now is.
But we created that.
Correct.
Yeah, but did we receive any federal funding?
I would have to check with other departments from DLNR's side. I don't have any knowledge of.
Aware of.
Correct.
Okay, this is rather interesting because it seems like it was a hot topic in Congress, and I remember what Congresswoman Tokuda has been sending us communications, and it was pretty active. CWARM, did you receive any monies for anything to do with Red Hill? They may not have known that you're not part of the discussions when we did this last year or a couple of years ago.
Vice Chair.
Here comes my Deputy Director. Oh, okay.
Can you please come forward?
And Ernie, if you know of anything as well, let us know.
Kira Kahavane, Deputy Director, Commission on Water Resource Management. We haven't received any direct funds, federal funds related to Red Hill.
Okay.
Senator, there was a federal appropriation that, or some federal funds that went to the Red Hill Registry, but that was to study the health implications similar to other events like Flint, to have a registry of those that are impacted by the Red Hill water crisis.
And that was a federal appropriation.
It was federal funding.
Maybe that took care of part of our problems, I guess. But I think the biggest issue we have in Red Hill is the main infrastructure and the problems that happened, several years ago. And that's why, we had at least set up a mechanism within, the legislature and the agencies to make sure we're on top of it. Ernie, you wanted to share anything? If you're aware. Oh. Thanks, Jura.
In terms of federal funding going to the state, and I'm not 100% sure, but maybe it's a question that could also be directed toward the Department of Health. I had thought that they may have received some funding support because
I remember
they were expending a lot of effort and cost in the response to Red Hill. I don't know if the funding came through the Department of Defense or through the EPA. I'd suggest that maybe set the inquiry toward the Department of Health.
Thanks, we appreciate that, and at least we know where we are. But I think coordinating with the Department of Health is important because this measure is not cheap. It's $11 million. Okay, thank you.
Senator.
Thanks for all you do as well.
Chair.
Further
Sorry.
questions?
Yes, please. DLNR, if you don't mind. DLNR, I have a question. Yeah, thank you. The bill calls for DLNR to seek reimbursement from the DoD. What happens if you guys don't get reimbursed?
That's a good question. I think we're still, understanding the mechanisms for seeking reimbursement, and so I don't have an answer right now, but I can find,
Sure. I'm just concerned that if you folks haven't gotten any appropriations yet, and there's not necessarily the plan to be reimbursed, that the state will continue to have to use its general revenues to keep funding this project. So I don't know if we're putting the cart before the horse, but sounds like you guys are still kind of figuring it out.
that too, and just seeking all available funding sources, federally, state, other programs that might be able to fund different aspects of the project. So we're seeking as funding it broadly.
Sure. You just don't have those numbers yet.
Well, for what we're presenting, or what was included in this, is the priority projects that would fund to, based on the initiatives that were established. These are some of the top priority projects. So this is what we're proposing to move forward with now.
Sure. And then the $11 million that you folks are requesting, I'm assuming that's a small slice of the pie, considering the overall cost that this is gonna.
That's a good point. It's the first step that we're initiating in a long process, right? What we understand is that this is something that will take years, if not decades, not of research, of understanding. We have a very different groundwater system here compared to anywhere else. According to the researchers, it's 99% different than anywhere else in the world. And so, yes, there's fuel contamination in other parts, but we have a unique system, and it's important to fully understand the implications of any kind of bioremediation that might be proposed as a part of the research.
Okay, I would be interested maybe at a future time to know what the breakdown of what the DoD is going to be investing, or the Navy or Department of Health. It really is their kuleana that they need to be responsible for this and take fiscal responsibility for this.
Yeah.
So thank you, Chair.
Chair, can I add to continue the discussion? And members, just as you know, once we delegate an agency like DLNR, you know that we're telling them to use their special funds. So I'm sure that's what the plans are. If you're gonna continue managing this program, that your first touch of monies is your special fund. So that means that they're going to be depleting some of their funds and on a new policy that we gave you to undertake. Thank you.
Thank you.
Good
Any
luck.
further questions?
Sorry, you can stay there. I just wanted to get clarification for part of that funding, the $4.3 million for environmental monitoring and testing. Can you also use that for monitoring wells?
So part of the plan of the environmental monitoring includes hydrology, it includes ecology, it includes streams, springs. And so monitoring wells are a part of it.
Okay.
Part of the consideration is being able to secure access to wells. So wells are a part of the scope and
Okay, I have a follow-up, Chair, if I may. So, if I recall, one monitoring well costs up to like maybe about $3 million. Kara, you can correct me if I'm wrong. I know you can. So that will take up like majority of that money already. And
so to respond to that, we won't be proposing any drilling of monitoring wells. It would be the monitoring and testing of existing
okay,
wells.
yeah, that was it.
Yes.
Okay, sounds good. Thank you so much.
Okay, any further questions? Seeing none, thank you very much. Let's move on to the next measure. SB 2002, relating to water, which allows the Commissioner of Water Resources Management to retain independent counsel. Repeals the first deputy to the chairperson, establishes the executive director, and administratively attaches CWORM to DLNR. Makes a number of other changes. Testifying first on SB 2002 is the Board of Water Supply. Good afternoon.
Good afternoon, Ernie Lau, Board of Water Supply. We support SB 2002. The issue of governance and it's clearly it was back actually in 1929 that the Board of Water Supply was created by the territorial legislature at the time. And the idea there was because water was such an important issue for the community at that time, and it is still even more important today, that they looked at ways to try to minimize the influence, and I use the word politics very carefully, not disrespectfully, but with great respect. Try to minimize politics or political motivations and decisions when it comes to critical water resources decisions. And it's worked for the Board of Water Supply for nearly 100 years. In 2029 will make our 100th anniversary. So I think that's a good model to follow, and this is somewhat along those same vein. I do support that because water resource decisions are intergenerational decisions. They affect not only the people today, but they affect it for generations to come. So I support that. We ask that when it comes to penalties, that the commission consider involving stakeholders in providing input into those penalty schedules. And also keep in mind that as a utility, a large utility, we have greater capacity to pay the penalties, but when the penalties are imposed on people that are not as economically strong, it could be a severe hardship for them. But I think the key point is to comply with the commission's orders and Malama our water resources. So suggest their stakeholder involvement in setting that penalty schedule. Thank you.
Testifying next, I apologize. These are slightly out of order, so to be state agencies first. My apologies. But that said, up next is the Attorney General.
Good afternoon, chairs. vice chairs, committee members. I am Deputy Attorney General Miranda Steed, and the Department of the Attorney General respectfully opposes this bill based on the provision that it requires independent counsel for the Commission on Water Resource Management. The Department of the Attorney General is uniquely situated to provide legal counsel to our state agencies. The department has a breadth of knowledge and experience that is unique compared with any other private law firm in the state. Additionally, representation of the commission goes beyond just litigation. And so while outwardly litigation would appear to be what most attorneys do, actually at the department, we do so much more than that. When it comes to advising our state agencies, we advise on issues relating to procurement code, to UEPA, to sunshine law. These are areas that private attorneys generally are not versed in and require a lot of advice and counsel back and forth with state agencies that we are uniquely equipped to make sure they are in compliance with. I'm available for questions. Thank you.
Thank you. Next on 2002 is DLNR, Seaworm. Good afternoon.
Good afternoon. Aloha chairs, members of the committees. Kira Kahahane, Deputy Director, Commission on Water Resource Management. I want to begin by expressing the department's appreciation for and support of the portions of this bill that relate to enforcement penalties and water shortage response. We respectfully refer these committees to the department's testimony on House Bill 306 and House Bill 510 from last legislative session. Those were on the same topics and address those provisions in more detail. With respect to the remainder of this bill, this ultimately reflects, I think, two different philosophies of governance, and neither is inherently right or wrong. Each has its own benefits and drawbacks. The department believes that the benefits of the current structure prevail. Those benefits include strong integration and coordination between the Commission on Water Resource Management and our sister divisions within the department. They also include a chair who works on a daily basis with issues of land and water management, who's current on relevant legal developments, aware of the department's administrative capacity and limitations, and is readily accessible. One of the most important features of the current structure is the alignment that it allows between the chair and the deputy director. In this department, that kind of unity and shared understanding is critical to effective administration and decision. Thank you for the opportunity to testify. I'm available if you have any questions.
Thank you. Signed up to testify next is Sierra Club of Hawaii on Zoom. Good afternoon.
Good afternoon, chairs, vice chairs, members of the committee. Wings Knox Club of Hawaii, we're in strong support of this measure. So the water code was passed in 1987. 30 years later, in 2017, water management areas were designated only in 3 places, right? Oahu, Molokai, and Nowaiaha. We only had science-based stream flow requirements for 14 of the nearly 400 streams that were supposed to have the stream flow standards. 6 of these was because the DAR administrator told the commission, testified to the commission, and he got fired for it, right? It's 30 years, that's all we got. And why? Because the code can require plantations and their successors and interests to share water. So they use their political influence to get the governor and the AG to hamstring the commission for decades, right? The state auditor called this out in the 90s. The person who wrote the water code was fired, Bill Tam, for providing too much water to the kalo farmers of Waiahole. The DAR administrator, Dan Pohemus, as I mentioned, lost his job. East Maui had to wait 20 years just to get an EIS while their streams were diverted the entire time, right? Requests for due process were denied again and again when it came to Hawaiian water rights, right? So, and you know what, from 2017, though, something changed. We had Khalil Manuel and the commission's Loea members were able to navigate the politics to implement the code. And we've seen dozens and dozens of streams restored for the first time in generations. We had an additional water management area. And then what happened, right? Politics stepped in again, and the Lahaina fire was used to scapegoat Khalil. So enough is enough. Please don't let please don't let DLNR's hand wringing keep you from doing the right thing after over almost 40 years, right? Please pass this measure. I do want to note that the Attorney General who just testified, the deputy, after the fire, misrepresented what happened and essentially was lied to the Supreme Court and was called out for it and was and again, just another example of politics influencing and undermining the public trust in water. We need this to stop. Thank you very much.
Thank you. Testifying next, signed up to testify next is Lahaina Strong. Oh, sorry, I'm sorry, Earth Justice.
Chair, good afternoon.
Afternoon.
Chair, committee members. Drew Hara, I'm an attorney with Earth Justice. So I first want to thank you, Chair Lee, for scheduling a hearing on this bill and recognizing its importance. And Senator Inouye, I know you've been a champion of this bill for several years now. And the importance of this measure, I think, is really aptly laid out in the preamble. In oral testimony today, I want to emphasize that the reforms in this bill are not hasty, short-sighted, or reflexive, and they're not targeted at any individual administration but they are really the product of longstanding recommendations coming from a review commission over 30 years ago. We also just heard from the Board of Water Supply how similar administrative structures granting more independence to the agency whose kuleana is to manage our public trust water resources has really benefited that agency and allowed them to operate independently and keep the resources' best interests in mind. Just would also highlight that had some of these issues been addressed earlier on, we would not have seen the same situation that we did in 2023 after the Lahaina fires, where the chair was able to unilaterally suspend interim in-stream flow standards, and the then deputy director was effectively dismissed without cause. In response to the AG's opposition to this bill, just wanted to highlight that with the Attorney General being the exclusive counsel for the commission, there have been times historically where the commission has been left without counsel, as in the Waihole situation, or been beholden to counsel that has been repeatedly overturned by the Hawaii Supreme Court. Also want to highlight that the provision in HRS 28 that the Attorney General has highlighted in the written testimony, which would allow for a retainer of independent counsel, would still be relying on a determination by the Attorney General's office and approval by the governor. So that provision does not provide the same type of independence or political insulation that this bill would. Last thing.
You can please summarize. You're out of time.
So quickly, the department cited unprecedented challenges as a reason not to move forward with this measure at this time. I would say these reforms will provide the type of institutional stability that we need to move forward. Thank you.
Okay, up next, Lahaina Strong on Zoom.
Unavailable on Zoom, Chair.
Okay. Also on Zoom, Lauren Palekiko. Good afternoon.
Aloha, chairs, vice chair, and members of the committees. My name is Lauren Palekiko. I'm the wife of a kalo farmer on Aina Kuleana in Kauaula Valley, Lahaina, Maui. I strongly support SB 2002, which will allow our Water Commission to uphold the water code and protect our streams and aquifer without political interference. Our ohana has felt firsthand what happens when political powers favor luxury developers and private water companies instead of abiding by our state water code, which is law. When the commission is pressured to look the other way, it is our community, our land, our food, and our traditional and cultural practices that suffer. This has led our Lahaina town, which has always been known for being a wet and fertile land, to burn down, killing over 100 of our people. After the Lahaina fire, the governor listened to the lies from Launiupoko Irrigation Company, or LIC, the private water utility that takes from our stream water and delivers it to luxury ag zone gentleman estates nearby. This led to Deputy Director Kaleo Manuel from being removed because he was Ke Kahuvaipono. Right now, the Water Commission's independence is compromised because the chairperson and legal counsel are appointed by the governor. That means whoever holds political sway over the governor can influence the commission's decisions, putting profit ahead of public trust. SB 2002 helps to restore balance by letting the commission choose its own chair, its own executive director, and its own legal counsel, strengthening accountability to the people, not politics. I also support adding stronger penalties for water code violations so that wealthy corporations like LIC and Maui Land and Pine can't just invest their fines back into their tyrannical businesses and continue to take more water, letting our streams run dry and aquifers suffer. In my allotted time, I can't begin to touch the devastation that's been done to our water supply. Our groundwater has been so overpumped that the salination levels have surpassed the EPA's threshold of safe drinking water
You're out of time.
for human consumption. Thank you. Including a nominee from OHA in the Water Commission nominating committee is an important
Thank you. We
step
have to stop
ensure.
you just to make sure we have time for all testifiers to.
Okay, I just have one more sentence. Is that okay?
One more sentence, real fast.
Our kupuna understood that water is life and we do as well. It connects us all and must be protected and preserved. Thank you for the opportunity
very
to
much.
testify.
Okay, up next is also on Zoom, Tara Rojas.
Aloha, can you hear me? Okay,
Yes.
aloha. Yeah, so for SB 2002, I strongly support this. And Kalamai, I believe I mentioned about the maintaining the distinction of the steamworm as its own independent entity and not having political influence or pressure from DLNR. When I mentioned the last one at Kalamai, there's a lot of videos. So that was relating to this one, SB 2002. So mahalo.
Thank you very much. That's everyone who had signed up to testify. Is there anyone else wishing to testify on this measure this afternoon? All right, seeing none, other questions? Just one for the Attorney General. I believe still back there. Thank you. Obviously, I think you've heard some of the testimony regarding the Attorney General's history with some of this, that as it's been relayed by others. In your testimony, you basically said there are the department has the expertise and authority and ability to provide counsel. Testimony seemed pretty clear that throughout its history, and quoting here, the commission has repeatedly been deprived of effective counsel or denied legal representation altogether at critical times. Can you speak to that?
Sure, we would respectfully disagree with that characterization. So I believe a couple cases that may have been mentioned, Waiahole was one of them. In most proceedings for the Commission on Water Resource Management, when it comes to designation, there's going to be many, many parties involved. And so there have been instances where there's another state department that is actually also a recipient or user of water. And so when you're talking about designation of water use permits, you're going to have one state entity that's also an applicant in that process. Actually, the most recent case the Supreme Court heard, the second Nava'eha decision, is actually a good example of that. State Parks was also an applicant. In that process, we had one deputy attorney general who represented state parks through the application process and represented its interests, and another deputy attorney general that represented the Commission on Water Resource Management. There was no issue. Obviously, the deputy attorneys general do not speak or interact during that time. It's frankly similar to when the department also manages enforcement actions. So, for example, there's numerous enforcement actions being brought by DLNR right now for different resource violations. I myself serve as tribunal for hearing officer and BLNR on a number of those issues, and someone else in my office will prosecute those issues because there's a contested case hearing before them. So I understand that there's a concern about when we have multiple deputy attorneys general representing on either side, but we put a China wall up. We're very careful to not interact. And our position is that that has not been a problem. If I may also address the, I guess, concerns about the attorney general not agreeing with commission decisions, I would also like to point out that I understand that may be perception by some groups, but at the end of the day, we as the attorney general represent the interests of the client. We litigate and defend them in court, and we advise them on what we think the law is. Our clients make their own decisions, though. So the decisions that the commission makes are the commission's decisions. It's not the decision of an attorney general somehow forcing them to decide a matter. It's their decision. And at the end of the day, whatever decision it is that commission makes, regardless of whether or not it followed advice and counsel, and I'm not saying that they don't follow advice and counsel or trying to disclose anything privileged, but regardless of whether they follow that advice and counsel is with them, between them and us, and we represent their decision in court at the end of the day. So I just want to be very clear that our role is limited to advice and counsel and representation. We're not dictating policy decisions made by these bodies.
In this case, you seem to be strongly opposing the ability for the council, or excuse me, for the council on water resources management to have outside counsel of its own, though, in its own right for whatever purpose. The gentleman from Earth Justice seem to I don't know if you want to come up as well, but seem to suggest that there would still be the ability for the Attorney General or Governor or the administration just in general to have ultimate say when the council when CWORM seeks its own counsel. Is that right?
So that's correct, that it comes through the Attorney General and the Governor, because you're discussing an expenditure of state funds to pay for a special counsel. We actually do have a number of special counsel that work with the Department of the Attorney General on a number of matters. Frequently they're brought in because it's something specialized that maybe is outside of normal state law litigation. And so we might call a more specialized attorney in. If CWORM had a matter that they believed they wanted specialized counsel for some reason to come in on, they could make that request. I'd like to point out, you haven't heard testimony that CWORM has been trying to request independent counsel and been denied that. They could make that request, and that would be decided between them and the Attorney General. But there's no allegation here that that somehow is happening and being denied.
Is that the testimony quoted was Earth Justice's testimony? In cases of repeatedly being deprived of effective counsel or denied legal representation, is that are you both speaking to the same thing here?
Yeah, I think that testimony, and specifically referencing the Wai'ole case where the Attorney General, who was in charge to the commission at that time, was ultimately dismissed because the Attorney General at large, that office, that department, did not support the position that the commission had been taking. And I also want to highlight that being able to, there's been sort of a dichotomy or a lot of emphasis on the subject matter expertise that the AG's office provides, which I don't dispute, but I would say that the option is not necessarily for private counsel. Under this provision, the commission would be able to have its own in-house counsel, something that's already done at other commissions like the Public Utilities Commission, where they have lawyers that are dedicated to that specific agency and handle sort of across the board.
Okay, thank you both. Further questions? Why don't we stick to this poll? All right, Vice Chair.
Well, just to add some historical background, and I'm glad that Ernie highlighted that this issue dates back over 100 years. And reason I personally introduced this measure, which has been around for 3 years, it was approved by both houses 3 years ago. It was held in the House on a political thing within their own sector. Nonetheless, it did pass. And I just wanted to share, to add to what Ernie did mention, in 1979, under Governor Ariyoshi, at that time, the Water Commission asked the governor that it's about time we should be in its own class, and that the authority should be established. So nothing happened. 1984, it happened again at a request to the legislature. And I believe during, I believe it probably was during Waihe'i's time as well. 1984, 1990, it appeared again. And reason I bring this up, I was a former planning commissioner member of the Hawaii County. And as a former mayor as well, I also was appointed by Governor Ariyoshi to be on the Hawaii State Plan Policy Council. We did 12 functional plans. One was the water plan. And I'll tell you, for Oahu, nonetheless, it was one of the worst data that we received, with the least amount of waters for its future populations. Hence, we're back here. And so I firmly believe, and I agree, and I'm glad that the water departments in the counties are in support of the measure. It's just about time. I think we need to get politics out of it. We have, every 8 years, we have new administration. Attorney generals come and go. So the Attorney General who's working with the commission now may not be here 4 years from now or thereafter. They have their own agenda. And I'm very concerned that we heard the importance of what our Constitution says, and it protects our vibe. Having said that, I'll stop here because our time is limited. So, so for my members, this is the reason that this measure keeps popping up again. And one of the things that I've omitted in this measure was the appropriation, because we really don't know if this measure will pass. If there's no appropriation for a position, then I don't want the bill to die. So in the event that, let's keep the discussion open, whether it continues on for the next couple of years, but hopefully we can put this to rest, get this in statute, and work on the measure as we move in the coming years. Thank you, Mr. Chair. Thank you, chairs.
Further questions? All right, seeing none, that is the end of our joint agenda. I'm gonna take a quick recess for decision making. Excuse me, recess.
Oh. Thank you. Returning to Senate Bill 2723 relating to State Sheriff's Day. Chair would like to recommend that we report this bill out unamended. This kind of acknowledges the role that the sheriffs have played, and we do want to make sure that we keep that legacy alive. For Committee on Public Safety, I vote yes.
Oh, yeah, I'm also vice chair of PSM, so this is interesting.
Yes.
Okay, voting on SB 2723, recommendation is to pass, I'm sorry, that was as is?
As is, correct.
As is. Chair and vice chair vote aye. Senator Hashimoto. Aye. Senator Inouye.
Aye.
And Senator Decort.
Aye.
Chair, the recommendation is adopted.
Okay, thank you. On Senate Bill
No,
17.
wait, sorry, one sec. So for Committee on Waterland, same recommendation.
Okay, the Committee on Water and Land recommendation by the chairs on SB 2723 is to pass unamended. Let's see, Chair Lee.
Aye.
Okay, Vice Chair goes aye. Senator Chang.
Aye.
Senator Lamusao.
Aye.
Senator Decort.
Aye.
Measure is adopted, Mr. Chair.
Thank you.
Okay, Senate Bill 17 relating to wildfire mitigation. Chair recommends that we defer decision-making until Monday, February 9th in this room, 3 p.m. There's a number of concerns that were raised. We'd like to amend the bill and bring that back to the committee.
All right, recommendation for Waterland is to also defer. We'll defer it to Friday, 2/13 at the end of our 1 p.m. agenda in conference room 224.
The next three are yours.
Yes. Okay, moving on to SB 2358, relating to search and rescue. Similarly, we'd like to defer this measure till Friday, 2/13 at the end of our 1 p.m. agenda in conference room 224, like chance to just coordinate with the stakeholders and continue the conversation to figure out what an appropriate set of amendments might be.
For Committee on Public Safety, we will defer to Monday, February 9th in the PSM time slot at 3 o'clock in this conference room 16.
Thank you. Moving on to SB 2475 relating to Red Hill. I'd like to move this forward. This goes to the Ways and Means and Judiciary Committees. We'll move it with amendments, blanking out the appropriations and noting on the committee report and adding in a defective date. Any questions, comments on this? If not, Vice Chair.
Okay, for the Committee on.
Sorry.
Oh, yes. Thank you, Chair. Just letting the committee know that I will be voting down on this bill. The president had signed into law on December 18th, 2025 fiscal year 26 National Defense Authorization Act, in which $6 billion was appropriated to Red Hill. So I don't want the money just to be left on the table. I think that if there is funds to pursue, the LNR should pursue that first. But there is money there. I do believe that they should pursue that first. So I will be voting down respectfully. Thank you, Chair.
So noted. Anyone else? All right, if not, Vice Chair for the vote.
For the Committee on Water and Land and Culture and the Arts, Chair's recommendation on SB 2475 to pass with amendments. Chair Lee.
Aye.
Vice Chair goes aye. Senator Chang.
Aye.
Senator Lamusao. Okay. And Senator Decourt.
No.
Okay. Measure is adopted, Mr. Chair.
Thank you.
For PSM members, same recommendation. Chair votes aye. Vice Chair Lee.
Chair and Vice Chair vote aye on SB 2475, recommendation passed with amendments. Noting all members present, are there any other reservations or noes? Noting the no from Senator Decourt.
Thank you.
All others vote aye and the recommendation is adopted. Then moving on to the last bill on the agenda, SB 2002 relating to water. Appreciate the discussion here. I'd like to recommend moving this forward. This goes on to the Judiciary and Ways and Means Committee. I'd like to pass it with amendments, making tech amendments, and in particular noting in the committee report that the Judiciary Committee should look at that issue over council, which seems to be worthy of a discussion as we go forward, and we'll see where it goes from there. Any comments or questions? Seeing none, Vice Chair.
Okay. The Committee on Water, Land, Culture, and the Arts Chair's recommendation is to pass SB 2002 with amendments. Chair Lee.
Aye.
Vice Chair goes aye. Senator Chang.
Aye.
Senator Lamusao. And Senator Decourt.
Aye.
Measure is adopted, Mr. Chair.
Thank you. For PSM members, same recommendation. Chair votes aye. Vice Chair Lee for the vote.
Voting on SB 2002, recommendations passed with amendments. Noting all members present, are there any reservations or noes? Seeing none, the recommendation is adopted. And with that, we are adjourned. Right?
Before you adjourn, could I make a brief
Oh, yeah.
announcement? Okay, for those who have been sitting patiently awaiting the PSM committee meeting, we do have your testimonies. The chair would like to ask people to stand on their testimonies, and we will defer decision-making to the Monday, February 9th agenda. So with that, you can go ahead and gavel out, and we'll gavel back in.
Thank you.
Good afternoon. Thank you very much for your patience and indulgence for many of the people who have been waiting. First measure on our agenda today is Senate Bill 2730 relating to criminal justice reform. The first measure on this agenda was canceled. So first up is Department of Attorney General on Zoom. She's present. Welcome.
Good afternoon. In light of your instruction, we'll stand on our written.
Thank you very much. We appreciate it. Testifying in person for prosecuting attorney, Mr. Hugo.
Good afternoon, Chair, Vice Chair, members of the committee, prosecuting attorneys.
Thank you. Next in person, Mr. Erdman, Retail Merchants of Hawaii. If not, next we have the policing project at NYU School of Law on Zoom. Welcome.
Good afternoon. Given your instructions, I'll stand on my written testimony. Thank you.
Thank you very much. Is there anyone else who would like to testify on Senate Bill 2730? Please come forward.
You skip.
Should have submitted testimony. I just want to make sure that the committee has it.
We have it.
Okay, and if you have it, based on your instruction, we will stand on our written.
Thank you very much.
Aloha Chair, Vice Chair, Committee members, Carrie Ann Chibota. I'm an attorney, community justice advocate. I strongly support this measure for the reasons that's been outlined by NYU Policing Project. I think for years we've been talking and we know that our jails are overcrowded 2 out of the 4. People who are inside are not getting the medical care that they need. And there's an uptick in suicides and people are being assaulted and killed. And so an arrest has consequences for people. So for lower level offenses, we'd like to see police have the authority to issue these citations instead. And during COVID, police in every county used citations instead of arresting for a number of types of charges. And there wasn't an uptick in crime. So let's utilize all the tools available. This is a best practice. Please pass this measure.
Thank you. Is there anyone else on Senate Bill 2730? Okay, if not, we'll turn to Senate Bill 2749 relating to sentencing. First up, we have Mark Tom, Deputy Attorney General. Michelle.
Stand on our written testimony in opposition to this.
Okay, thank you. Next, we have Office of the Public Defender.
Good afternoon, Chair, Vice Chair, members of the committee. Thank you. Just very briefly, we've outlined our testimony, but I do just want to say that if the committee has concerns, we would invite a conversation to go into more detail about the nuances of the bill, how critical it is, can provide more information about our current sentencing scheme, which will emphasize why something like this is so important for the judges to be able to consider. Other than that, I'll stand on the written testimony and be available for questions.
Thank you very much. Next, we have Office of the Prosecuting Attorney, Mr. Hugo.
Good afternoon, Chair, Vice Chair, members of the committee. I just want to briefly outline what it takes for someone to be sentenced for repeat offender sentencing. What it means first is that this person committed a felony. Second, this person was convicted of that felony. Third, this person committed another felony. Fourth, that felony occurred within 5 years for a class, if the predicate is a Class C felony. Fifth, the prosecutor charged it. Sixth, that person got convicted again. Seventh, there is a jury trial on the question of repeat offender sentencing. And eighth, the judge decided not to depart downward from the mandatory minimum, which they are already authorized to do. After all of that, enough is enough. We strongly oppose this bill.
Thank you. Next, we have Community Alliance on Prisons, Cap Brady. Or her designee. If not, turning to Senate Bill 2688, relating to compassionate release, Director of Department of Corrections, Johnson.
I'll be brief. I just wanted to summarize some important key areas in our testimony. I'm Tommy Johnson, Director of the Department of Corrections Rehabilitation. We do not oppose compassionate release. However, we do oppose compassionate release consideration for those people who are serving life without the possibility of parole, life with the possibility of parole. We also note that this measure does not allow for a mechanism for family members of victim or surviving victims to provide input prior to the release, and that we would also require resources if this measure were to pass as is. Thank you.
Thank you very much. Next, Hawaii Paroling Authority, Mr. DeMello.
Good afternoon, Chair, Vice Chair. I'm Corey Ranke, the Administrator of the Hawaii Paroling Authority. Just for the record, also, we oppose the bill with suggested amendments, which is in our written testimony. And I also wanted to add, there's a very large view that DCR and HPA is the reason for the delay of these inmates being released from a facility under the compassionate release, and that is not the fact. I can let you know that I called 100 care homes one day to try to get housing for a compassionate release case. And once they found out they were going to be on parole, they denied my request. So we're doing everything we can to try to work with community members to find places where we can house them. But that's really where the delay is. We set them to grant them, the paroling authorities grants them parole, but finding appropriate medical housing for them has been difficult. Thank you.
Thank you.
We're available for any questions.
Thank you. Next, Office of Public Defender, Haley Chang.
And the chair's instruction will submit our written testimony in support. Thank you.
Thank you. Hawaii Correctional Oversight Commission. Kristen Johnson. Next, we have Office of the Prosecuting Attorney, Mr. Hugo.
Good afternoon, Chair, Vice Chair, members of the committee. Just briefly, I do want to note our department does not oppose compassionate release in cases of terminal illness. However, I do want to emphasize two very important things. Number one, this bill does not have any provision for victim input, not just notification. We'll do that. That's our moral responsibility, but victim input. Some victims forgive the offender, some don't. Both are valid. And when this society broke its promise to victims, which is what happens when that crime was committed, we have a moral obligation to ensure that they are not forgotten. The second thing is that this bill, there are many provisions in it that we believe are overbroad and will be manipulated. Somebody who did not hesitate to rape a child or who took a life without remorse will not hesitate to throw back your compassion at you if you do not word these provisions very carefully. Thank you.
Thank you very much. Next, Hawaii Disability Rights Center, Mr. Erdeshik.
Thank you, Senator. I'll be brief. We've been working on this for a long time, both advocating it as a policy and case by case. I've worked with Bob Morris over the years. The beauty of this bill is that it formalizes what is now a very ad hoc scattered practice. There are some people that do get released compassionately, but there's no real formal process. Bob works in some of these cases. Sometimes they get released, sometimes they don't. So this creates a structure. This is not a get out of jail free card just because you're sick. I mean, there's a whole process. The parole board has to review it. A lot of times these are people that committed crimes, maybe serious crimes when they were much younger, but now they're old, feeble. And so not only is it humane, but even if you're looking at this totally as a cold calculating number cruncher, I was kind of laughing because Tommy Johnson is complaining about the resources this is going to take. Take a look at how much money is being wasted on the current system. He doesn't have enough money to do what he needs to do to fix the prisons at the moment. If these people are released into the community, not only is it cheaper to serve them there, but they can go on Medicaid and the federal government will pick up half the cost. So these are the most expensive prisoners imaginable. And Bob and others can probably tell you more about that, but it's way cheap. It's a no-brainer economically to try to get them out in the community and get them served that way. So between that and the humane aspect, it's just, to me, this bill makes common sense all around. Thanks.
Thank you very much. Next, we have Demont Kalai Manaole on Zoom.
Not present on Zoom, Chair.
Okay, next we have Community Alliance on Prisons, Cap Brady.
Aloha committee, I'll be really super brief. Thank you so much for hearing this bill. It's about the humanity and the values that we have as a community. At a recent informational briefing, one person, it took $2 million to provide what he needed. These are people who are really ill. They have chronic and, irreversible diseases. Another person spent $900,000 of the department's budget just on medication. And then shortly thereafter, I received an anonymous email from someone in the department saying, we have no money for medication. And then I started receiving calls from families saying, my son didn't get medication, and what he's really worried about is people who need psychotropic medication are not getting it. So this is a really important bill about our values and about how we spend our money correctly. Thank you.
Okay, thank you. Next, we have Hawaii Health Harm Reduction Center, Mr. Leverance.
Aloha, Madam Chair, Vice Chair, members, Nikos Leverance with Hawaii Health and Harm Reduction Center in strong support of this bill. Just to emphasize what we heard earlier today, Hawaii is the only state without a compassionate release law on its books, and we should join the rest of our states on that front. Mahalo.
Thank you. Next, we have Lynn Costales Matsuoka, Sex Abuse Treatment Center on Zoom.
Unavailable on Zoom, Chair.
Okay, thank you. Next, we have Ohana Ho'opakele. In person, a representative. Okay, if not, we have Molly Crane testifying for FAM in person.
Hi, everyone. Thank you so much for having me all the way from Chicago. My name is Molly and I work at FAM. We're a national nonprofit, nonpartisan organization. We've worked on compassionate release for 25 years. And there's just a few points I'd love to emphasize in our support. The first is that in the federal system, in every state but one, there is a compassionate release statute. And that's because people who are critically ill are the most expensive to incarcerate, the most burdensome to care for, and the least likely to recidivate. Hawaii is the only state in the country where this program is not governed by statute. There are a lot of great features of the bill. There's just two that I will emphasize today. The first is eligibility criteria. It's best practice around the country that the eligibility criteria is based on medical factors and an individualized determination rather than categorical exclusions. People serving mandatory minimums and/or LWOP are eligible for compassionate release in the majority of parole-based states. This is common practice. This is because of what we all know. People are costly, burdensome, and least likely to recidivate, and this is true irrespective of sentence or conviction. The second is the importance of timeliness. People with critical illnesses are deteriorating very quickly, and so in this bill, we've set deadlines and timelines. We have asked that the 60-day notification period be waived. However, this does not preclude victim notification or input. It just says that it's not practicable to wait 60 days when someone has a terminal illness. I have visited Halava myself on many, many occasions, and I've seen the harms of this bill not existing. And so we respectfully urge you all to pass this bill, which will reduce costs, support staff, provide dignity, and promote public safety. Thank you.
Next, Chanel Santiago Hall as an individual. Okay, next, Mesana, an individual. Welcome.
My name is Mizana Eldiker, and I am a ex-correctional officer who had life experience with inmates dying on us, and we're not trained as nurses. There was this one incident where the inmate was dying of AIDS, and there was no help for her, no visitors. But my job was to keep her shackled, both hand and feet, throughout her coma. And I really ask that you guys support this bill because, nothing beats, dying with your family, at least being unshackled. I thank you.
Thank you. Next, Robert Mercy.
Fukunaga, Vice Chair, lead members of the committee. My name is Bob Merce. I'm a retired attorney. I've been working and helping people seeking compassionate release for the past 10 years. And I'm here to testify in strong support of this bill. As they've said, several people have said we don't have a compassionate release bill. We do need one. We worked on this bill, and by we, I mean the group of attorneys, primarily all from here, with the expertise of 3 of the best attorneys in the country from FAM who worked with us. We worked for 9 months to present this bill to you today. And this bill represents best practices without any doubt. And so I hope you'll look at it from that perspective. One of the blowback, I guess, that we're getting is that we believe that every single person who's incarcerated by the state of Hawaii ought to be at least eligible for compassionate release, whether they have a life without parole or a mandatory minimum sentence. Doesn't mean they're going to be released. It means they're eligible to be considered on a case-by-case basis. And the law clearly states that if the person is a danger to society, they may not be released. Finally, I just want to say that I can understand people saying life without parole, we should just keep them in. We do not have the facilities to take care of these people, mentally ill people, people with Alzheimer's disease who need a quiet environment. We got people now in our infirmary with brain cancer, brain tumors, glioblastoma, ALS, and really devastating diseases because they're old people and those diseases set in. And we are not staffed, or we don't have the physical facilities to take care of those people. So the best practice right now would be to get them into the community where they're less expensive, and it's where they belong, because they're going to die there in peace. That's what we're really trying to do. So thank you very much.
Okay, thank you very much. This is the end of my list of testifiers. Okay. Okay, let's see. One additional person, Shelby Pikachu, billionaire on Zoom.
Unavailable on Zoom, Chair.
Okay, anyone else here to testify on this measure? Okay.
This special release,
Yes.
okay. It's a, no, oh, thanks. Huh? I'm 76.
Good afternoon.
Good afternoon, Chair. Chair, I don't know the protocol. My name is Vankyoki Kahumuku. I'm currently the president of Ohana Ho'opakele, which is the Rescue of Our Nation translated. And we're trying to get all the inmates. I'm trying to get all the inmates. You're just talking about compassionate release. The reason they're in prison is because a foreign country decided to put us, our people, in another foreign land called the United States. Now, if they kept us here, we could have been useful to the community. Learn how to do something to right what we did wrong. Okay, we could have been here working in the community. Some of us need a little bit more help than others. And that's why we need to use the pu'uhonua concept. You know what a pu'uhonua is? Okay. Whatever people are in that community make the rules. It's a decentralized system that worked for Hawaiians or the natives for thousands of years, all the way up to when we left a place called Babylon to come to Hawaii. And what I'm trying to do is get rid of this system so that we don't have any of us in the prison system. We get other ways to handle our people in such a way that they become better citizens. It's called peer group thing.
I'm so sorry. Can I ask you to begin summarizing we're almost
Yeah.
out of time.
Get rid of that state prison system for us. We're a kingdom. We're a different country.
Thank you for your testimony. Okay,
Hi, everyone. Hi, my name is Gail O'Lyon. I have a shared mantle to an organization called God Forgives Bad Boys and Bad Girls. Compassionate release moved me to be present because I do have a personal situation in this. I'm hoping that such is extended to my husband, Mana O'Lyon. But of course, this is at the federal level. For those who knew my husband, I believe can say that there are individuals that can be rehabilitated even prior to incarceration, or to believe that there is a setting supporting sustainability while incarcerated. The truth is, it's not so if you are incarcerated in a state prison. Nothing really available, not enough, nothing to rehabilitate an individual. I know as I have experienced both myself, state and federal incarceration. So I speak from experience. My heart goes out to an individual who has a state charge. Take two people, give each of them a 10-year sentence, one at the federal level, one at the state level. The impact and the journey differ greatly. At a 10-year sentence, it would seem like a 20 and so forth. Life without could compare to a death penalty. Hawaii does not have a death penalty. My hopes are that this bill finds a way to allow compassion to be extended to people incarcerated in Hawaii. I am moved to give voice as a supporter to this bill in hopes that to extend such possibilities of compassionate release to all people that have served the length of their time, and at the same time, that the shift to costs allow more to go back into rehabilitating an individual rather than caring for them with costly medical needs. I support this bill. Thank you.
Okay, members, we have one more bill on the agenda for which we'd like to take testimony. Okay, Angela, very short.
Angela Melody Young, testifying on behalf of Kapalama Neighborhood Security Walk. In strong support to raise awareness about reducing incarceration and recidivism across the state. I'm in strong favor of the compassionate release. So there were other bills about inmates who have past traumas. And then I brought up the concern that inmates with disabilities, mental health, anxiety, they're combating suicide or PTSD, and the circumstances that they grew up in that they were not properly treated for, and they end up being offenders because resources were not provided to them. Then they end up in prison. So that's not good. And so to have this measure to help reduce the burden of the state, I think is a good idea. And I think an amendment could be considered for a task force of mental health professionals, faith-based ministries, active in incarcerated ministries. So I help with God Forgives Bad Boys and Bad Girls. And also to include in the task force faith-based programs, providing mental health support for inmates, to gather the nonprofits and businesses that are already doing the work in the community to come up with legislations for next year, for the task force to include DLE, Department of Law Enforcement, Department of Corrections and Rehabilitation, HPD, and DHS, to focus on the public health, public safety, and the corrections aspect of managing compassionate release based on
can you begin wrapping up, please?
Inmates that have disabilities. And so, also, especially inmates with disabilities that have special needs, the impact of an arrest is scary. So anything that we can do to help them,
Thank you very much,
would be
Angela.
appreciated.
Okay, members.
Sure, good job.
Chair, Vice Chair, committee members, Carrie Ann Chirota, I strongly support this measure for medical, humanitarian, for also fiscal reasons. I think it's been stated before, to annually incarcerate one person without medical problems, it's over $100,000. And on average, people with complex medical care needs that we're referring to, terminally ill, et cetera, we're looking at anywhere from $600,000 to $900,000. Nearly $1 million. That money can be better spent helping people get into the community, get medical insurance, and provide for the care that they need. When we also keep people inside, we're also preventing their families from able to spend their last days together with one another. And I'd also like to share that individuals who even commit the most heinous and serious crimes are capable of rehabilitation and redemption. I previously worked as a director for Maui Economic Opportunity Reintegration Program, and we worked with individuals convicted of Class A and B felonies, people convicted at one time of murder, manslaughter, rape. And individuals, when they got the support services they need, were able to transform their lives, reunite with their families, and give back to the community. And I also would like to say, not only in that respect that I saw people transform, but I think a lot of times people who are pushing for more punitive policies invoke the name of victims. And I want to share with you that my family has been impacted by crime, and I am a survivor of violence. My uncle was murdered on Maui when I was 6 years old, and whoever murdered him was never arrested, never convicted, so they're out in the community. And yet if they were to go to the emergency room or seek care, they would receive that. And so I think the compassion is at the heart of this bill. Aloha, we have the aloha spirit, we need to practice it. And this just makes fiscal humanitarian self. And I just want to end with a scripture, because for myself, I'm a person of faith, raised Buddhist on one side of my family, but also Catholic. And there's scripture that remember those in prison as if you are bound by them. And we ultimately are interconnected. And I humbly ask that you pass this measure.
Thank you.
My name is Edine Stanley.
I have a father who's been incarcerated for almost 40 years. His name is Edward Stanley. He is
Can you identify yourself, please?
Edine Stanley.
I'm Thank Eddie you.
G. Stanley.
Edmene Stanley. Thank you. Okay,
Anyways, my
please
dad's been in
proceed.
there for almost 40 years. He has life without parole. He did not kill anyone, but he does have sickness. And we would love to have this bill, this compassionate bill passed. I do believe everybody in this world do make lots of bad choices. And I do believe that people that's incarcerated could have a second chance to in life, you know? But other than that, yeah.
I mean,
That's,
as me and my two siblings are here, he's the baby and I'm the baby sister. We didn't have our dad for so long, but I got the chance and my sister got the chance to see him in person. After 30-something years, I'm not feeling that feeling of a dad. So this compassionate, we believe that my dad have a second chance and everybody else that is in that system. But the justice system failed my dad from the beginning for his sentencing. And that's all we can share for now. And we just leave it up to you guys on you guys making that decision for the compassionate part for our family too.
Thank you.
Thank you.
Thank you for letting us share.
Okay, one last bill on the agenda. We have Senate Bill 2798. This is relating to law enforcement, making the agricultural enforcement pilot program permanent. I don't see any of the testifiers who submitted testimony present in the room. Excuse me, please come forward.
Really brief, Senator, thank you. I'm Jared Rizzo. I'm the Deputy Director for the Department of Law Enforcement.
Oh, okay.
Our department is in support of this. The agriculture enforcement program is vital for food security, biosecurity, and to make sure that farmers and ranchers and those in the agriculture community are not victimized by crime. I can tell you that since Duke's Law was passed by you this past July, we've had very regular and very frequent calls over agriculture enforcement crimes. And as a result, we are very busy. So we look forward to this passage of the measure and support it. Thank you.
Thank you. Okay, I received an updated listing. So on Zoom, do we have Maya Hunter?
Not present on Zoom, Chair.
Okay, also Shelby Pikachu, billionaire on Zoom.
Also not present on Zoom, Chair.
Okay, that brings us to the end of the agenda. And I do apologize to those who have waited a long time, but we appreciate your being here and we will take up decision-making on Monday, February 9th at 3 p.m. in this room. Thank you.